Hello everyone, welcome to Excellence IAS Academy. In this case, we'll discuss about Adhoc Judges. What is the context? Recently, Supreme Court issued fresh guidelines with respect to appointment of the Adhoc Judges. Before going to discuss about these fresh guidelines, we'll discuss about first the Adhoc Judges and also the provision of Constitution with respect to appointment of the Adhoc Judges. And later we'll discuss about Lok Bharari case, in which the Supreme Court previously had laid down some guidelines, and also discuss the new guidelines also. Let us begin. The Adhoc Judges. Adhoc Judges. Adhoc Judges are the temporary judges. Means they will appointed by the Chief Justice of the particular High Court to act as a current High Court judge. But they are not a permanent High Court judge because they are a retired High Court judges. Constitution Article 224A gives the power to the Chief Justice of High Court to appoint a Adhoc Judges. This 224A article, which was inserted in 1963 by 15th Constitutional Amendment Act. This article says that Chief Justice of the High Court can request any retired High Court judge to act as a High Court judge. But it says that the High Court judge can only request any retired judge to be appointed as High Court judge in only two conditions. Article 224A says that the Chief Justice of the High Court can request any judge with the prior consent of the President, and also with the prior consent of the retired High Court judge who is being appointed as a High Court judge. But these retired High Court judge who is being appointed as High Court judge will receive allowances decided by the President, not the Parliament. These allowances will be decided by the President himself. But over a period of time, Supreme Court thought that it was mere consent about Article 224A. Why? If the cases are pending in the High Courts and vacancies are also present in the High Court, means new fresh appointments are being made to the High Court. In this condition, the Chief Justice of the High Court can go for appointment of the Adhoc Judges. It may lead to halt in the new appointments in the judiciary. Because of this, High Court means Supreme Court had laid down some guidelines with respect to this appointment of the High Court judges in the High Court. Lok Bharari case. In Lok Bharari case, in this particular case, Supreme Court had laid down some guidelines with respect to appointment of the Adhoc Judges. The first one is that the Chief Justice of the High Court can go for the appointment of the Adhoc Judges only if the vacancies in the High Court is exceeding more than the 20% of the sanctioned strength. This is one condition. And second condition is that if certain category of the cases are pending more than the 5 years, means for example, if criminal cases are pending in the High Court more than the 5 years. In these conditions also, any particular Chief Justice of that particular High Court can go for the appointment of the Adhoc Judges. And third one is that if 10% of the cases in that particular cases are pending more than 5 years. In this condition also, Chief Justice of the High Court of the particular High Court can go for the appointment of the Adhoc Judges. And fourthly is that disposal rate. If disposal rate in any High Court is low, what is the disposal rate? The rate at which new cases are being filed in that particular High Court is much more than the old cases are being disposed of. In these conditions also, any particular Chief Justice of the High Court can go for the appointment of the Adhoc Judges. But recently, High Court found that around 62 lakh cases are pending in the High Courts across the country. 62 lakh cases are pending in across the all High Courts. And 18 cases, approximately 18 lakh cases are with respect to criminal cases. Because of this, Supreme Court issued a fresh guidelines with respect to appointment of the ad hoc judges in the high courts. What are those guidelines? One is that Supreme Court had said that the ad hoc judges are only eligible to hear criminal cases. Means the ad hoc judges should not hear civil cases. Second one is that the number of the ad hoc judges are appointed by the High Court judges, the Chief Justice of the High Court, should not exceed more than the 10% of the High Court sanctioned strength. These are the fresh guidelines issued by the High Court with respect to appointment of the ad hoc judges in the High Court. But with respect to speedy delivery of justice, the judicial appointment should be much more proactive. So appointment of the ad hoc judges is a secondary and should be at the last resort. So fresh appointments of the judicial appointment should be made to deliver a speedy justice. So thank you for watching the video.